Schwartz. I am a professor and a lawyer, and I'm going to introduce you to Moot Court. Moot Court is an exercise that's actually typically done in law schools. It's a very new thing to do it for middle schools. And this replicates, it simulates what we call courts of appeal, which are the courts in our judicial system after trials and before the Supreme Court. Now, it's usually a law school exercise, but this is something that 8th grade scholars absolutely can do and can have a lot of fun and a really rewarding experience doing. So what is it? For some people, they might be thinking, hey, this sounds like mock trial, which at higher achievement, scholars do in 6th grade. But it isn't a trial. A trial is where judge and jury find out what happened. Did John steal a bicycle or not? And they'll hear evidence presented from by lawyers. I saw John steal a bicycle. John couldn't have stolen the bicycle because I'm his sister and I was there with him when the bicycle was stolen. And that's what happens in a trial court, and that's what the mock trial scholars are doing. Appellate courts decide questions of law. They don't hear evidence in the sense of, I'm a fingerprint expert, or I'm the eyewitness who saw John steal the bicycle. They deal with questions of law. Did the police do something illegal when they arrested John? So, he can't be convicted because his rights were violated. Famous questions of law that have gone before the courts that a lot of people will recognize are, for instance, can we have segregated schools? No, we can't. The Supreme Court said, no, we can't. That's a legal question. We don't present evidence, is the segregated school nice or is it not? We look at the legal question of what our Constitution requires. So in Moot Court, scholars simulate what happens in those courts of appeals when judges are considering questions of law. Now, how does that happen? So the scholars are presented with what we call a case record. It's a story. It's a story that we've written about an issue that scholars, we think, care about, which is discrimination, and in particular, discrimination in the way students are treated in dress codes. And the question is not, is there a dress code, or did someone violate the dress code? The question is, can a school district have a dress code like this at all, or does it violate our right to be free from discrimination, in this case, based on our sex or gender? So how will the scholars act as lawyers in an appellate court? Well, they'll do it a lot like lawyers do and a lot like law students do. They'll write a statement explaining why the law comes out on their side. If they're representing the school district, they'll describe all of the reasons that a school district is legally allowed to have a dress code like they do. And if they're representing the students, they'll write a statement describing all of the reasons that the dress code violates the rights of students, that it discriminates, that it's based on stereotypes. They'll stand in front of a panel of 3 judges who will be volunteers, and this is just like an appellate lawyer, just like a law student. They'll make their case, and then they'll have to answer questions, original questions, from the judges, just as an appellate lawyer will do. Over the course of Summer Academy, they'll build from learning what the law says about stereotypes and sex discrimination in schools, through how a lawyer does this, building their opening statement, and then practicing with their peers to be ready to defend themselves. Now, this isn't about becoming a mini lawyer. You're going to see in a moment an example of an undergraduate doing an oral argument just like our case, the same case the scholars will do. But this is someone who's, not an 8th grader. She's doing that at a higher level. But what you'll see is that this is the exercise they're going to do. The thing to keep in mind as a teacher is that you're not building mini lawyers. What you're doing is helping the scholars explore their voices, become someone who can stand up before a bunch of adults, make their case and defend their case, to behave professionally, to argue logically, to use a legal rule that they're learning in Summer Academy. And they absolutely have the power to do that. when you think about getting them ready, think about all of the reasons that lawyers and citizens and advocates might want to use their voices, might want to be able to prove a case, to argue both sides, to consider the holes in their arguments, to consider why their side should win, why their opinion matters. And any scholar that's doing that and is ready to have a conversation like that is going to have a very successful moot court.
I'm here to show you how you can set up your moot court room. So oftentimes you'll have the two advocates sitting at different tables with a space in between, or they'll be sitting at one table next to each other. Behind the two advocates is where you'll have scholars who are not doing their arguments. And then over here, you'll have a podium where the advocates will put their speeches or their outlines on to give their presentation. And then facing the speaking or the scholar giving their presentation are the judges, so that they're looking at each other, and then you have the scholars not giving their presentation sitting behind them so that the advocate speaking does not have to look at their other scholars. So the first thing that we would do for this presentation is you'll have the judge call up the first advocate speaking. So
counsel for the appellant, please approach. Counselor, you may begin.
May it please the court. My name is Astonique Robinson, and I represent BN, DM, and CJ. Today, this court must decide whether Arkansas school districts have the right to enforce unjust student dress codes, alienate students, and engage in gender discriminatory practices. The question that the court will answer today is whether Little Rock School District has violated the Equal Protection Clause of the 14th Amendment by establishing an overbearing and discriminatory dress code policy. We strongly believe that the Little Rock School District has violated the 14th Amendment rights of students by creating and enforcing such a policy. The 14th Amendment provides equal protection under the law, and we have seen that in the Little Rock School District, that equal protection is being denied. We are aware that in school environments, a student's rights can be circumscribed, but there is a difference between circumscribing rights and denying rights. In this case, students are being targeted for dress code violations based solely on gender. Male students have been reprimanded on numerous occasions for wearing hooded sweaters while their female counterparts just skate by. Likewise, there have been numerous accounts of male students wearing shorts that violate the dress code, but there has been no intervention by the administration. Little Rock School District contests that these policies are enforced fairly regardless of gender, but the evidence in this case suggests otherwise. The punishment for dress code violations is severe and has the power to impact the future of students who are reprimanded. Colleges, employers, and other future opportunities will be made aware of these infractions. If this code is not being enforced fairly, then it should not be enforced at all. In many ways, this policy places an undue burden on the students and their families. In the case of DM and BN, the financial burden is significant. In order to comply with the school dress code, these families must go out and purchase an entirely new wardrobe. In the case of CJ, the burden becomes more significant. CJ, unlike other students, is being denied the right to identify and express their gender or lack of gender the way that they see fit. It is not the place of the Little Rock School District to identify CJ's gender and mandate a dress code based on their assumptions. Even when CJ is following all clauses of the dress code policy, they are still reprimanded. The reason CJ is being reprimanded is for gender expression, nothing else. The Supreme Court decided in the 2013 case U.S. v. Windsor that it is unconstitutional to deprive people of liberty by making them second-class citizens. This interferes with the equal dignity of all citizens. By forcing CJ to conform to the societal view of what gender should be, the school district makes them a second-class citizen and denies them liberties that other students have. Little Rock School District claims that these policies are put in place to combat numerous social issues, but in many ways this policy perpetuates and even heightens the same issues that they aim to solve. They claim that this will diminish sexualization and consequently decrease eating disorders and other health issues. By forcing students to cover parts of their bodies, it sends a message that their bodies are the issue. We have seen that as a result of this policy, students have been made to feel uncomfortable in the classroom environment and that they have been bullied. Students have been called crude things like stupid queer and have been alienated for their body types. The school environment has become more hostile than ever, and this code takes away from the students' ability to learn. The court is free to strike down legislation that interferes with liberty unless the government can demonstrate that they are seeking to achieve an end that is not arbitrary, capricious, or unreasonable. There is no evidence that these issues are prevalent in this school district. There's also no evidence that this dress code policy has made the school environment safer, more accepting, or that it has made students less susceptible to sexualization and gang involvement. When a policy incites bullying, creates unnecessary financial and social burdens, and so serves no purpose for the school district or the students, we must draw the line.
Counselor, you mentioned this case involves gender-based discrimination, but to me this seems like normal standards between boys and girls. Aren't there real differences between boys and girls, and can't we have different requirements based on that?
Judge, if we're talking specifically about the anatomy of boys and girls, then yes, there are differences. But if we're talking about gender and gender expression, then it's difficult for us to draw a line and say, or mandate to students that they are male or female, they're a girl or boy, and tell them this is the way that you must dress as a result of what we see that you are. It takes away from the students' right to identify, it takes away from their form of their self-expression, and it alienates them in a school environment.
So, you mentioned liberty and freedom, yeah, liberty to express yourself, dress the way you want. This is important, but liberty in middle school, it isn't the same as out in the world. The students can't wear bikinis. So, where would you draw the line here? Would you prevent the Little Rock School District from, let's say, banning bikinis? Or is that too much too?
Judge, I'd say that clothing that actually has been proven to incite issues or distract from the learning process of students would be under the jurisdiction of the Little Rock School District to actually, create a policy that combats that. So in that case, bikinis would obviously take away from the educational value of attending school, and that would actually be something that would incite an issue. But in this case, we're saying that shirts that may show the collarbone or hoodies that have not been proven to cause any problems in the school environment should be banned.
Okay. But, it's complicated, it seems to me, because in some communities, a collarbone wouldn't be distracting or inciting, and in some it very much would be. That seems like a community standard, different degrees of modesty, different families even. Why can't we let the school decide what is distracting? I mean, these are professionals, principals, people who know all about kids.
I think that it's important for the Little Rock School District to act on precedent. And so, as of right now, there's no indication that students in the school wearing hoodies actually have gang affiliation. Now, that would change the case completely, and if they were to have gang affiliation and that was creating issues, whether in the community or in the school, then it would be appropriate for Little Rock school districts to say we're banning hoodies and here's why, here's a reason that we're giving. But in this case, they're going based on other trends that are happening in the U.S. and not necessarily things that are affecting this specific community.
Okay, in Olson v. Board of Education, the court ruled that a school could prohibit boys from wearing earrings because it was a sign of gang violence. What makes the Little Rock School District case different, and why can't they ban hoodies if this other court was able to ban boys from wearing earrings?
I'd say that in the Olson v. Board of Education case, there was an actual threat. There was a threat of danger, and if there are students involved in gangs in the school and they're being connected in the school through this symbol of earrings, then that poses a threat not only for the community but for the students of the school as well. And it also can become a tactic for recruitment. What we see in the Little Rock case is that students are just wearing hoodies because they're wearing hoodies. There's no affiliation to outside criminal activity or gang affiliation, and so there's no reason for their right to wear a hoodie to be restricted based off of assumptions of what could happen in the future.
So would you say that the potentiality of a threat is where you draw the line?
I'd say that if we have clear evidence that there is a connection between clothing and some illegal activity and that could severely affect the community or the school, then we'd have to draw the line and create a restriction there.
So, Counselor, I'm glad you brought that up because I'm inclined to agree with you about this question of the hoodies. You're right, the record doesn't have evidence, for instance, about gangs. This makes a lot of sense what you say. The Little Rock School District did say that sexual harassment is on the rise. They presented all of this evidence, across our country, bullying, harassment, so-called sexualization of girls, where they're treated like sex objects. and they wanted to do something about this. So, is that not enough, knowing that across this country middle school girls are being subjected to this so-called sexualizing? What more does Little Rock need to be able to take action?
I'd say in this specific case, it's difficult for us to say women are being sexualized, let's have them change a dress code to cover up their bodies. That sends the wrong message to the students. First, to the people who are being targeted, that it's their fault that their bodies are uncovered, and that's the reason that they're being targeted. And it sends a message to the entire school community that once their bodies are covered up, the issue is gone. And unfortunately, that's not the case. I think what Little Rock School District needs to do is take this on a case-by-case basis and look at specific students who are being targeted and focus not so much necessarily on the victims in this case, but on the perpetrators and how they can educate or how they can institute programs that are going to help those students and prevent that behavior in the future.
Thank you.
The goal of our teacher's guide, which you are going to so the goal of our teacher's guide, which you are going to receive, is so that you can be prepared, so when your scholars have questions, you know how you can answer, and so you know how to set up a moot court and just move through the process slowly. So with our teacher's guide, at the beginning, we have a list of goals of what we are saying that we would like our curriculum to accomplish, in particular based on our lesson plans and the outlines. Reading through that will help you understand better what the goal of this project is and how you can help implement it better for your students so they understand. Our content is very flexible, but there's lots of pieces in there that can help you understand better what you are teaching your students. One is we have an introduction to what appellate court is. This is important because this is the type of court setting that the students will be working in order for the scholars to truly understand and implement the moot court process perfectly, you need to understand what the appellate court is. Then we have a learning outcomes and goals for the program, so I'll show in there what the learning outcome and goals for moot court is. Then we have a piece on what mock trial is versus moot court. A lot of students have completed mock trial earlier in school and probably in higher achievement, so there's a little bit of discrepancy between the two. It can get confusing, so helping the students understand what that is can help them clearly define what their moot court experience is going to be like. Next, we have a description of why appellate courts are important and what kind of cases are heard there. We have some casework and case studies that are available in the teacher's guide and in the scholars packet so they can see what appellate court cases look like. Next, we have a background on constitutional law, why constitutional law is important, and how it ties into the appellate court and the cases that they'll be working on themselves. And then we have a glossary at the end. This glossary is going to help you understand the terms. That way you can also define terms for the students if they ask. Being prepared to use legal jargon is very important in this, and hopefully this will help you out a lot so you can implement your moot court in class.
What is your best advice for scholars preparing for their oral argument?
I'd say the best advice I could give is having a clearly structured outline for them, because going into this, it's difficult to know, exactly what an oral argument really is and what it should entail. So if you give them specific blocks of information of what should be there, so starting out with introducing themselves, explaining who they're representing, and then going from there to explain kind of what they're arguing, framing their argument, and using case law, I think that gives them just a sense of comfort in what they're doing so that they know they're actually following some steps and they're not just going on a whim and writing an argument.
Definitely. And how can scholars best prepare for the questioning section?
I think I found that in my experience, the best thing to do is to work with someone who's arguing the exact opposite of what you're arguing. Usually because their best points are your worst points, and by hearing what they have to say and what they plan to present, it helps you to be one step ahead and have answers to those questions and find the holes in your argument. So it can really just be constructive for you both to sit together, find those holes, and like then separately obviously go work and figure out how to patch that up. And then I think also having someone else hear your argument or hear you speak, they can tell you what sounds weird, because all the time we don't know necessarily how we're sounding. Tell you what sounds weird, tell you when you're going too fast or too slow, work with you on cadence and things like that.
Great, thank you.
Thank you for watching and have a great summer and Moot Court experience.